automatically recorded. So good evening, everyone. You're all very welcome to tonight's first legal webinar series of 2025. I hope everyone had a nice Christmas break and that you're remaining unscathed from the adverse weather that we're experiencing, or some people are experiencing around the country at the moment. We have over 100 people registered for tonight's webinar, and we're just going to give people time to log in before we begin the presentations. The webinar will be recorded tonight and it will be available on our YouTube channels also. So I'm delighted to be joined by Gareth Noble, who is a leading human rights lawyer and partner with KOD Lyons. My name is Michael, and I work in AsIAm on the legal policy and the information line team, and I'm delighted to be co-presenting tonight's topic on law and education with Gareth. Some of you on the call may be familiar with the work of Gareth and the work of AsIAm. And you're all very welcome, and thank you for signing up. So Gareth is going to look at the general areas of the right to an education and children's right to access the curriculum, and that will cover areas such as the assessment of need piece. It would look at the Irish exemption piece, and I'm going to cover in particular the reduced timetables and the legalities around suspensions and expulsions in the Irish schooling system. I'm going to speak for around 20 minutes, and Gareth will speak for 40 minutes, and then there will be an opportunity for people to submit questions into the Q&A box. And I would ask that if people are submitting a question, they would do it over the course of the presentations. And once the presentations are finished, then we will proceed on to the Q&A. The Q&A session will not be recorded. So the only thing that will be recorded from tonight's webinar is the introductions and then the presentations from Gareth and myself. So on that note, we have people still coming in, Gareth, but I think we might begin, and you're going to speak for around 40 minutes and then hand over to myself, and I'll speak for around 20 minutes as well, and then we'll open up to the Q&A. So over to you, Gareth.
Good evening, everybody, and thank you for your attendance in such good numbers on, I think it is the coldest night of the year, if it's not already outside, and I know that some of you, particularly in the Munster region, are particularly feeling it, so so thank you for attending. I think on nights that Liverpool are playing as they are tonight, there are very few organisations or very few people that could persuade me to prioritise something other than Liverpool. But I'm delighted to say that when you get an invitation from Michael and AsIAm, that absolutely does become a priority. AsIAm have done unbelievably hidden as well as valuable work in terms of promoting educational rights, in terms of highlighting educational disadvantage and deficits, and really playing such a positive role both in the public awareness in relation to the need to vindicate the constitutionally protected rights that our constitution provides us with, and also to really, I guess, make it an issue of public consciousness and policy formulation. So certainly tonight's session is important, and I thank AsIAm for organising it for us all. I think it's probably impossible over the course of 40 minutes to tell you and to advise you properly in relation to what the constitutional or educational rights framework is. So you'll appreciate that this is a bite-sized insight into the types of issues that I would come across and that AsIAm would highlight also. And there are, of course, many topics that we won't be able to cover either tonight or indeed in any real depth. But the first thing that I would say is that when it comes to educational rights, we have much stronger legal rights in the area of education than perhaps we have in other areas of everyday life. So our educational rights are much more strongly protected than, say, for example, our housing rights or our health rights, for example, because of the fact that they are centrally bound to that constitutional guarantee. And what the constitutional guarantee provides us with is a very real and clear commitment, an unequivocal commitment, that the state will provide for an education for children. And how that has been interpreted by the courts has been really interesting through a whole range of constitutional cases and other matters which are really relevant to the delivery of education for children. And I guess what I want to look at tonight is, how do the courts interpret that constitutional guarantee? And then more importantly and more significantly, what are the practical consequences of what the courts have said to us arising out of that constitutional support? When you think about it, really, the Constitution is a contract between the state and its citizens, and it provides what it can provide, and sometimes with, of course, exceptions and provisos. And when it comes to that provision of education, the way that the courts have interpreted that is that what is placed on offer to that individual child as an individual rights holder must be suitable, must be adequate, and must be appropriate to meet their educational needs. And so when we have cases that involve, for example, no school place, or a school place that is perhaps um, lacking in some aspect, or lacking in some type of support, or indeed perhaps being placed in a school that is not matched to what our assessed needs are, well then the question for the courts really is about the adequacy, the suitableness, the appropriateness of what is on offer. And quite a lot of the cases that I've been involved in over the last number of years have really been about those children who don't have school places, and where in fact therefore the constitutional issues are very much engaged with. And then those cases where perhaps children are in school places and are enrolled in particular schools or schemes, and the adequacy appropriateness has to be tested. And then the courts will then make a determination that what is on offer meets the constitutional guarantee or not. Apart from the Constitution, of course, then we have statutes, so the Education Acts, the EBSIN Act, which of course is now under review at the moment in relation to children, particularly with additional educational needs. And the department itself then operates through the use of circulars, which are effectively a way of the policies of the department in terms of the administration of certain schemes and certain policies. For example, there is a circular on S&A provision and what the role of an S&A is, and the role of the S&A, of course, a special needs assistant being to ensure that the care needs of the child is being met, so that they can access their curriculum on an equal basis with their peers. The assessment of need process that Michael referenced at the start can be very helpful in establishing the profile of the child, and can be very helpful from an educational perspective in assessing perhaps what supports a child might need through an educational journey. The second important thing, of course, is that in the context of an assessment of need under the Disability Act, a referral can be made by the Assessment of Need Officer to the National Council for Special Education for an educational assessment to be done of that child. And that has been the subject of some court litigation and some court commentary. And this is an emerging, and there are some legal issues arising in relation to who should conduct those assessments and how they can be then implemented in the context, both in terms of an educational planning context, but also in the context of the wider position in terms of meeting a child's assessment of need that would necessarily impact on their ability to access the curriculum. So, for example, in terms of speech and language therapists, in terms of OT, in terms of psychology involvement, and so on. And indeed, it's very striking that in order to try and get out of the siloed approach perhaps that we have been in for far too long, that I think it was the consensus of all the political parties during the last general election campaign, that we really need to look at models around schools, starting with the special schools, to ensure that actually those wraparound supports, that scaffolding in terms of speech and language therapists, OT, psychology, can perhaps be brought into the school environment in a way that enables children both to receive those therapeutic supports, but also designed to help them access the curriculum. And we watch this space in terms of the programme for government, which is being negotiated as we speak. So in terms of school enrolment, therefore, it is the obligation on parents to make sure that applications are made around school enrolment. There is obviously a scheme around homeschooling that is outside and separate to that. But for the most part, we have a situation in which parents are obliged to, from a school-going age, at the age of 5, to ensure that their children are enrolled and attend school. And of course, we know that if a child then is enrolled in a school and doesn't attend for more than 20 school days, in fact, it is open and it is mandated on schools to refer those cases through to the school educational officers that operate under the auspices of TUSLA around school attendance. But what about those children, of course, who don't have a school place, or who have a school place that is wholly unsuitable to meet their needs? And of course, we know that for the most part, we have children who are in mainstream educational environments who may require additional supports. We then have a network of autism classes that have been established within those school settings. And then we have a separate category of special schools, which are, of course, make no distinction between primary and secondary, and which cater for those children with more complex educational and care needs from the age of 4, quite possibly through to the age of 18. We don't have a legally enforceable right to an individual education plan under the EBSN Act. That part of the EBSN Act was never, in fact, implemented. But it is seen as good practice. And certainly the Department of Education almost insists on the provision of educational plans in order to assess the type of supports that a particular school needs. And for many children, particularly for children who are autistic, the challenge of going into a school environment can be very overwhelming. And we know, for example, for children who perhaps have speech and language difficulties or sensory issues or processing issues, that can be a very, very challenging environment. And therefore, we have to look at what supports does that child need in order to be able to access the curriculum. And so the school enrollment piece is important because if a child who in fact has been assessed as requiring an autism class, and we're talking about a maximum of 6 children here, are their needs being met in a classroom with 32, 33 children, even perhaps with some SNA access? Because if it's not, well then that constitutional guarantee is questionable in terms of whether it is delivering the vindicated right for that particular child. And so much of this depends on the individual circumstances of an individual child. And whilst there has been a great rush to try and sometimes make children fit within particular criteria and particular schemes, from my perspective, the start, middle, and end point of all of this is that these are rights that are enjoyed by children on an individual basis. And therefore, as the courts have so interpreted, it is a matter on an individualized basis that determines whether or not the child's educational plan is adequate, suitable, and appropriate. We know, for example, that it used to be the case that special needs assistants who provide incredible and unsung, in many respects, support to children to access the curriculum, that it used to be the case that a child would have their own individual SNA and that an application would be made based on the profile of that child for that child to be sanctioned an SNA. That model, of course, is now gone because instead schools are invited by the department and the NCSE to submit effectively a whole school evaluation of the profile of the children within their school, and then a block of support is identified for children, not based on the individualized assessments of individual children, but on the needs of the school community as a whole. And I consider that, frankly, to be a regressive step, that model, in terms of meeting, if we're looking at the individualized position of an individual child, because we are left in a situation in which, in fact, principals are left in the invidious position of allocating a block of support that they have been provided for by the school as a whole to the individual children within that school environment. And it can be a real wrench on school management to try and ensure that the delegated role that they have been given to provide the day-to-day support for children can sometimes be properly vindicated. Now, what can be done in relation to that? Well, there is within the department a scheme that is referred to as the exceptional review scheme. And that means, therefore, that if a school is of the view that they do not have sufficient adequate resources to meet the needs of the children within that environment, they can make an application for an exceptional review to the department. That in itself is laden with certain difficulties, and I was involved in a case in Mayo last year where a referral has now been made to the Ombudsman for Children by the court to look at the operation of that exceptional review scheme. That involved a child in the care system who had suffered a lot of early life trauma and loss. And so there is an ongoing Ombudsman for Children investigation into the adequacy of that scheme in terms of meeting the individual needs of the child. Because what we established in evidence in that particular case is that the CNOs who undertake the exceptional reviews attend the school and attended a particular school in the West where they, by their own policies, were not able to bring the material and the reports away with them to consider as part of the exceptional review, where they were only in a position to attend the school for a short number of hours in terms of looking at the needs of the school as a whole, where, for example, uh, some of the children to whom needed the additional support were not in fact present on the day that they attended, and where in fact the decision makers included people who were not even there at the on-site visit and had not even received or had ever had any sight of the paperwork or the school observations in relation to that exceptional review. So there are issues and there are challenges for schools and for CNOs who are undertaking these exceptional reviews, and I anticipate that there will be further developments in relation to that type of model of providing additional supports for children as we move into the future. So, what other types of schemes are there from a very practical level in terms of supports that are available? Well, I'm just going to list a small number of examples of them, and the criteria is very important to be able to avail of these schemes. And it's very, very important from a practical sense and from a legal perspective that we understand what the criteria, we understand what schemes are available, what the criteria for them are, and who's making the decision and how do you appeal that decision. So those are perhaps issues that AsIAm and KOD Alliance can advise individual people in relation to. But let me say this from a very practical perspective. There is only one guarantee in life that you will not get that support, and that is if you never apply for it in the first place. I could paper every one of your living rooms with examples of where parents and teachers were told, you're not going to get this support, and therefore that's the end of the matter. We only know whether or not a decision can be challenged if we have a decision to challenge. And in order to have a decision to challenge, you need to have an application. In order to have an application, you need to understand the criteria yourself, and therefore that you are bringing the relevant information as part of that application based on engaging with the criteria. There is, not just in education law, but in public law generally and in human rights law generally within the state, whether it's social welfare, whether it's employment type situations, whether it's any decisions in terms of education, a duty to give reasons. So the decision maker cannot simply turn you down without giving you sufficient reason. And indeed, there's a very interesting decision in a social protection context delivered by a now recently retired Supreme Court judge, then sitting in the High Court, Miss Justice Mary Baker, who said that when somebody applies for something, there is then a duty and an onus on the decision maker to engage with the evidence that has actually been presented. So it's no longer good enough simply to say your application has been refused. That doesn't meet the test in terms of that legal duty to give reasons. And so if we look at what types of schemes and supports that might be available to individual children, well, first of all, there is the issue of how do I get to school in the first place? Particularly that there isn't a legal right, as bizarre as all of this sounds, there isn't a legal right to be educated in your local community. And so we spend millions and millions of euros transporting children from their local communities to the nearest school that has been identified to meet their needs. And we spend, as I say, particularly in the South Dublin area, going into the outer reaches of the Garden County of County Wicklow, lots and lots of money in terms of providing in providing that. And so in terms of being able to avail of school transport, to be able to avail of bus escorts, for example, to be able to avail of, of concessionary transport schemes and so on, it's really, really important that we understand the criteria and get the application forms and look to see how do we go about providing that. And all of that information we can make available to you, and indeed is publicly available online in any case. But in terms of school transport circulars, it makes it very clear that you must attend, in order to avail of that, you must attend the nearest school that is suitable and resourced to meet your needs. And we went through a whole plethora of cases where, in fact, CNOs were simply looking at the nearest school rather than the nearest school that is properly equipped and resourced to meet the needs of that child. And that caused significant issues, but significant progress has also been made in relation to that. And if you're turned down on the issue of, am I attending the nearest suitable school or not? Well, then, of course, the School Transport Appeals Board sits in Athlone in order to address those types of issues. So it's not just a matter of getting the Google Maps out and looking at what is the nearest school. That's not where the full stop is. The full stop is later on in the sentence. And so that is important. You're in school. We've talked a little bit about SNA support. What is the role of an SNA, and the fact that it is the school ultimately who make the decision about who will be availing of the SNA access based on the level of resources that they have been provided. And there can be very good examples, and have been very good examples, of parents and schools getting together in relation to SNA provision and making a very compelling case together to ensure that those constitutional rights have been vindicated. Other types of schemes that you might want to look at, assistive technology applications can be incredibly. Had one of these cases today actually involving a child in second year in secondary school, and the importance of getting an OT assessment that will help uh, secure that assistive technology application and the use of a laptop. And we really kind of want to get this in place because obviously next year is a big year in terms of junior cert, and having that not coming at an overwhelming time, but having that well in advance in order to that to become an integral part of everyday learning as it moves towards the junior cycle. Irish language exemptions are probably one of the main areas that I see. And it used to be the case that there was a very fixed policy in relation to Irish language exemptions. And there was a High Court case, I think it's about 2 years ago, probably at the stage that we're involved in, which meant that there was a more flexible system that developed thereafter, where you actually looked, and it goes back to what I said earlier, at the individual position of that child rather than a fixed policy. Can I say something a little bit about fixed policies in educational law? Irish courts do not like fixed policies when it comes to educational law. And the reason for that, of course, is that it doesn't look at the individualized position of that individual child. And it comes back, of course, again, if we look back to the constitutional, providing that guarantee to that child as a rights holder. Fixed policies, in effect, unlawfully fetter the discretion of a decision maker to be able to provide that support if they feel that they should. So that's not to say that there can't and shouldn't and won't be criteria in relation to matters. But for example, when it comes to an Irish language exemption, there is now a greater degree of flexibility than there was heretofore in relation to looking at the impact that the compulsory nature of of Irish language classes, the compulsory nature, the impact that that would have on that individual child, in terms of anxiety issues and in terms of other matters that impact on their ability to access the curriculum, not just in terms of Irish, but in terms of their other subjects and the knock-on domino effect that that has as well. In terms then of reasonable accommodations for exams, that's probably another, fairly big building block when it comes to the types of schemes that are available. And again, these types of schemes and supports change all of the time. And again, when you get into fixed policies, or you get into that's only available for a child with this particular diagnosis, but not that diagnosis, that's where it becomes all fairly problematic. Okay. And so, in terms of reasonable accommodations for exams, those are state exams. So they talk about, obviously for junior cert and for leaving cert and leaving the leaving cert applied program as well. But a big question arises, of course, as to when does when should that type of support be introduced? And this is where the law is quite silent on things. Is it just for the exams? Is it in the run up to the exams? Should it be part and parcel of your curriculum as you embark on the examination process? And I think that's also very important, because when we think about it, a lot of our final results and our final outcomes in relation to exams now, particularly at Leaving Cert, are of course not just based on two exams at the end of sixth year, but involve continuing coursework and continuing provision. And if you don't have that support through that as a continuum of support, well, then the question does arise, you know, have those educational supports, have those reasonable accommodations, and the need to have them, uh, have they been compromised by the timing at which they've been introduced? So that's an important thing that I think is also a new trend and a new pattern which will take us forward. So I mean, we've talked about the laptop, the use of the laptop, but I mean, you are talking about things like, extra time in an exam. We're looking at, scribes who will perhaps write out answers. We're talking about readers, and all of these supports have had fluctuating emphases along the road. We're talking about things like, being able to take time out during an exam, for example, or about having the exam in a different room or a different center for concentration issues and being overwhelmed in a situation. All of these types of tailored supports um, that are there. One of the things that we did find as a trend, of course, was that the timelines that were set down for applying for these things and then for a decision to be made meant that if the decision went against you, you were almost too late to appeal it, because exam season was upon us. And so those are things that we all have to bear in mind in relation to the adequacy of an appeals process, because again, it is a fundamental part of our administrative law generally, and educational law in particular, that you have to have a right of review or right of appeal. And if it's not an adequate remedy, then it's not an adequate support. Because there's no point in having an appeal on the 1st of June when you've sat the exam on the 30th of May. So in conclusion, and before and for once I'm actually ahead of time rather than behind time, but in conclusion, I guess what I'm saying from an educational context is, and I use this phrase a lot in these types of sessions, is that for children in the Irish educational system, children as individual rights holders have many more rights than they think they have, and many more rights than they're led to believe that they have. And I think that's really important to bear in mind. Um, and finally, I guess it's also important to say that whilst I have focused very much on the relationship between schools and children and state provision and state supports, it's also very important to emphasize, and Michael is going to touch on this a lot more, is that sometimes even within the schools themselves, issues and challenges can arise in relation to the manner in which that educational provision is rolled out on the ground. And of course, every school has to have two policies on their website. One is an enrollment policy. And of course, if you enroll a child and you are not um, successful, there is the Section 29 provision, which allows you to appeal that failure to enroll. If you apply for schools and you are refused entry to all the schools that you've applied to, well, then it becomes a matter for the Department of Education, in my view, to identify a school that you can make an application to enroll your child in. And if that isn't provided to you, well, then that's where the constitutional breach occurs. Um, but uh, it would be important that if you cannot enroll your child in a suitable school or a school at all, it is important that you keep your paperwork. It is important that you're able to demonstrate the efforts that you have made to try and enroll your child in that school. And then ultimately, it is then a matter for the Department of Education, in my view, to vindicate that child's right by identifying that suitable and appropriate school for you. And if they fail to do so, then that is where you take a legal action against the state. But as I said to you, there is also issues of concern that might happen in relation to the delivery of education and the delivery of supports. It might be movement breaks, it might be sufficient allocation of SNA time, it might be about what type of supports the child is being given, in terms of resource teaching hours, etc., etc. Those things have to be dealt with under the school complaints procedure. So the second policy that is on every school's website should be the parental complaints procedure. And before you can go down a legal route, or before you can go to the Ombudsman for Children to look at this from an educational perspective, you do have to demonstrate that you have engaged or sought to engage with that school complaints procedure. And that school complaints procedure is effectively the same virtually in all schools, but it effectively involves two aspects. One is informal resolution. That is step one of the process, where you actually have to try and informally resolve the issue of concern to you. And that involves you bringing that to the attention of the person against whom you have the complaint, whether it's the teacher, whether it's the year head, whether it's the school principal. And then a meeting has to take place between you and them to try and resolve matters. And it's only then, if that cannot be resolved through that informal resolution, that stage two then takes you to a position where you are making a formal complaint to the Board of Management, and that triggers the formal process. And the only person who can stop that process is you, the parent, because there are clear timelines within virtually all school complaints procedures about the timeline by which each stage within the complaints process needs to be adhered to and to come to a conclusion. And that ultimately, if it goes through all the stages, is a matter for the Board of Management. And it's only when you get that decision that really then, from a legal perspective, you can look at what that decision is and what legal options you may have post that. So a lot of people that come to me or come to AsIAm would be around navigating through that school complaints procedure, seeing it through, and then also assessing at the end of that process where it leaves you in terms of the area of concern and how we go about progressing that further if there are grounds to do so. Finally, what I would say is that, in very rare and exceptional circumstances, relationships of trust between schools and parents sometimes break down. And that is obviously regrettable. And sometimes it is, in fact, from my perspective, it is, in fact, sometimes Department of Education policy that can trigger that, because some of these policies, of course, sometimes, unfortunately, pit parent versus principal, particularly when it comes to SNA provision that we talked about earlier. And I had a consultation earlier today where, in fact, the ultimate decision was made that the child would benefit from a fresh start in another school. And that was a very difficult decision for any parent to make. But what they have found in that new school, which they were lucky to secure, is that that has provided a fresh start for all concerned, particularly the child, and that child who has perhaps had school avoidance issues and has had difficulties in that old school, have completely vanished and disappeared and is thriving in their new school environment. So that happens, very fortunately, in a very small number of cases, but sometimes in terms of school enrollment, that has proved to be the ultimate resolution in relation to ensuring that the child's access to the curriculum can be as powerful and as enriching and as a positive experience as it can possibly be. So thank you again for your attendance tonight. I'm obviously happy, along with Michael later, to take any questions that people may have in relation to any issue of general concern that they have. You'll appreciate we cannot give individual legal advice or guidance to people through this type of forum. But of course, if you do wish to follow up with us in relation to matters, we are always happy to look at individualized queries. So thank you for your attendance and your attention, and I'll hand back to Michael now to deal with his presentation.
Thanks, Garrett. And I have included some links in there for the chat to direct people to AsIAM's contact information as well. Thanks for your expertise and your insights into this particular topic. And I suppose as a token of my appreciation for taking the time whilst Liverpool is playing tonight, I do hope that there is a win for Liverpool. I hope people can see the screen, the presentation in front of them. We will share the presentation slides in the days after. But as Garrett said, I'm going to touch upon two particular topics on tonight's presentation, that being reduced timetables, looking at what a reduced timetable is and looking at in particular Circular 4721, and looking at suspensions and expulsions and looking at the school legalities around that and recourse to suspensions and expulsions. I do see a couple of people are putting their hand up. This forum doesn't allow for us to open up conversation to members who are attending tonight. But what I would say is if you do have a question, please do include it in the Q&A box. And I know some people have sent me one or two questions directly, but we'll get to answer those at the end of the presentations. So I suppose from the outset, looking at what is a reduced timetable or reduced school day, as some people might be familiar with it, it's when a school puts your child or young person on reduced school hours, and this could mean, as the presentation shows, that the start to the school day is later than normal, or the finishing the school day is earlier than normal, or it can sometimes mean whereby a child might not complete the full school week. Now, what I will say from the outset is um, reduced timetables, they can have a place if they're used effectively and appropriately to meet the needs and the profile of the child who is in school. But what I would say is that when a reduced timetable is introduced by the school, the school must show deference to the child's rights to an education as identified in the Constitution. And Garrett alluded to that earlier on, is that the right to an education is the only socio-economic right explicitly referenced within the Constitution, and therefore has a particular stronghold in terms of rights, and your children or young person as rights holders. So it is important to keep that in mind if, for example, a school is suggesting that your child might be put on a reduced timetable. In 2021, the Department of Education introduced guidelines around the use of reduced timetables. I suppose for some context, what was happening was there was an inappropriate use of reduced timetables in schools, and AsIAM and other organizations, and indeed Garrett, I'm sure, is familiar with some of those whereby school reduced timetables were being used as a first resort instead of a last resort. And sometimes what was happening is that children were being put on reduced timetables as a result of the school not having the appropriate means or resources to meet the needs of that child. That in itself is unlawful. To put a child on a reduced timetable as a result of a school not having appropriate resources, that's an indictment on the system and a reflection in those cases on the Department of Education not meeting the needs of the child. What the guidelines do is that I suppose they set out the framework that the school must comply with in terms of the guidelines. So, for example, there's on the presentation there, you'll see that the school must outline the reasons for the reduced timetable. Consent must be received from you in the first instance. I will come back to when consent is not given in a couple of moments. And a plan must be put in place to support the child whilst on the reduced timetable. The guidelines show that the arrangement should be for a limited period of time, not exceeding 6 weeks. And during that 6-week review, there should be a plan put in place, which could be linked to an independent education plan if one is in place for the child, or the student if there's a student support plan in place for the child. And that needs to be monitored over the 6-week period that child is on that reduced timetable. For example, you could have a child who might be on a reduced timetable, only doing 2 hours of school each day for the first week, and then the second week that might be increased by a half an hour or maybe an additional hour. But it shows signs of progress to get the child back into full-time education, and that should be the goal of reduced timetables, in order for the young person or the child's right to education to be vindicated. Because I said there are cases whereby they're used as a first resort and that's inappropriate. If, for example, after 6 weeks, the timetable needs, oh sorry, the reduced timetable needs to be looked at again, renewed consent is needed on behalf of the parent or the guardian. And as Gareth said from the outset in his conversation, the TUSLA, the Educational Support Service, must be informed when a child is being put on a reduced timetable. I just want to go back to the issue of consent for oh sorry, I'll hold off. I'll just speak to this slide here for a moment. This is just an outline of the guidelines that were introduced by the department, and it just shows that the school must comply with the guidelines with respect to the process proceeding to the implementation of a reduced school day or a reduced timetable, and they must follow the process outlined in the guidelines, and again notify TUSLA for to inform them that a child, one of their students, is put on a reduced timetable. In relation to consent, and this is really important point. So consent can be withdrawn at any time a child is on a reduced timetable over that 6 week period. And indeed, a parent in the first instance may not give consent to have their child put on a reduced timetable. And that is a prerogative and a right that the parent is entitled to make known to the school. If the school proceeds with the reduced timetable without the consent of the parent or the guardian, or indeed if the child is over 18, 18, and that constitutes, or that would be what you might consider a de facto suspension. And if that is the case and a child is on a reduced timetable for more than 20 days, well, then the typical procedures or the internal procedures that are applicable to a suspension would apply to a situation whereby a student is put on a reduced timetable. So if the child's non-consented reduced timetable surpasses the 20 days in the academic year, and the parent or guardian can action or can go down that route of the section 29. I will come back to the section 29s in the next part of the presentation, which is particularly looking at suspensions and expulsions in the legal context. To suspend a student or indeed expel a student from a school is a very serious step for a school to take. And as Garrett referenced again, that the right to the education is enshrined in law, both in terms of the Constitution and in terms of legislation also. Um, you'll see under section 23, section 23, subsection 2 of the Educational Welfare Act, schools are required to include procedures for suspensions or expulsions in their codes of behaviour. And such procedures must apply the principles of natural justice. And I've captured that in two areas, the right to be heard and the right to impartiality. And I'll come back to those in a few moments. But just in the context of tonight's presentation, under that particular piece of legislation which is referenced, parents are required to sign up to the code of behaviour of the school. Without signing up to that school's code of behaviour, a school is within its right to refuse enrolment to a school setting. So that's something to be mindful of, particularly if you're new to the educational journey or your child is starting off school this coming September or indeed next year. It's important to read the school's code of behaviour in advance, and schools are required to have to have published on their website their school codes of behaviour, or at least disseminate their code of behaviour to an incoming student, their parent or guardian. So under legislation, every school's code of behaviour, well, sorry, every school's code of behaviour is different, but it must be legally based and underpinned by the current guidelines and codes of behaviour. And they were currently produced in 2008, and they're called the Developing a Code of Behaviour Guidelines for School. TUSLA is currently, or the educational division of TUSLA is currently reviewing those guidelines. And indeed, organisations such as ourselves and other advocacy organisations and parents have been involved in the framing or inputting our engagement in what those frameworks, or that framework should look like. Just quite interestingly, AsIAm produced an independent piece of research, which I have linked into the chat box on the Zoom, a piece of independent research which looks at codes of behaviour. This was funded through the Irish Human Rights Equality Commission's grant scheme. And what this research looked at was 40 codes of behaviour randomly selected across the country, which was made up of special schools, primary schools, and secondary schools with an autism class and without an autism class, and looked at their codes of behaviour through the lens of the UNCRPD, that's the United Nations Convention of the Rights of a Person with a Disability, and the UNCRC. And it looked at the articles within that particularly relevant to children with additional needs and their rights to an education. And of all of those 40 codes of behaviours that were randomly selected by an independent researcher, none of them were considered to be rights compliant. And that's obviously quite a concern that we would have as an organisation. And we know from our experience, either via our casework team, that a code of behaviour, going back to the parent or the guardian signing up to it at the start of the school year, it can be used or held against the student in relation to situations that may arise. So it's important to be mindful of the content of your students, your school's code of behaviour, and if indeed you are starting the educational journey next September and you're meeting with the principal, no harm to engage with them on their school's code of behaviour, so you can get a full sense of what's expected of your child or your young person. Um, so going back to the right to be heard piece, which comes back to the whole area of natural justice. And I know that sounds quite a highfalutin term, but it's important just from the outset, because it's important that if your child is suspended, or indeed there's an expulsion hanging over their head as such, that you're familiar, or you have an understanding as to what is expected of you and what you should expect of the school. And I've just kind of captured a couple of pieces here. So for example, the right to know that the alleged issue is being investigated, the right to know that the details of the alleged allegations being made and any other information that will be taken into consideration, the right to know that the issue will be decided upon, and the right to respond to the allegations or respond to the issue that you have been informed of in relation to a situation that might have arisen in your son or your daughter's school setting. And then also the where possible, the sanction, if the sanction is of a serious nature, the right to be heard by the decision making body. And more times than not, that would be the board of management. So they're just areas that if you are in the unfortunate position where your child has been suspended, or indeed there's a pending expulsion, these are some of the areas that you should expect from the school, or should expect from the school, in terms of what should happen over the course of the suspension, and then the process and the procedures that would kick in thereafter. It's also important to note that the act of suspending a child or a young person must be proportional to the issue at hand, and that goes back to the nature of the incident, and then also the guidelines, or the rules, or the codes that are enacted within your child or young person's code of behaviour. And then the other piece then is on the right to impartiality. This is a fundamental to the area of natural justice. Freedom from bias entails ensuring that a person with an interest in the matter is not involved in the investigations or the decision making. So if a person has preconceived opinions, or a vested interest, or personal involvement in the matter, then they should not attempt to settle the matter. For example, an incident might be involving a teacher. Well, it's not prudent or wise or fair for that teacher then to investigate that matter, because they are directly involved in it, and so on. So that's where the right to impartiality comes in. And again, that's framed under the auspices of natural justice. So the next point that I want to look at is, so if my child is suspended or expelled from school, and I've just put a couple of points within the presentation. So the board of management is the the board of management of a recognized school has authority to suspend a student. This authority can in some cases be delegated to the principal. And as I said earlier on, the suspension should be proportionate, and must be in keeping with the school's code of behaviour. And I'll refer to a case later on that captures that in particular. Before a student is suspended or expelled from school, the school should have exhausted all means to prevent or mitigate against a suspension happening. And things that you might look at in that respect is, what supports have the school tried, and over what period as such. How have the supports been recorded and monitored by the school, in order to mitigate against an incident involving a suspension happening. And if there were supports put in place, what has the results been in relation to those supports being put in place. And these are important features, especially if you as a parent were to take a section 29 against the school. And this is, as Gareth said, it's the legal mechanism. This is where a legal mechanism would come into play in relation to going down the section 29 route. It's important to note that there are different types of suspensions. If you go on to if you read the current guidelines around the framework on codes of behavior, you will see the different types of suspensions that are put in place. There's an automatic suspension, or there's an immediate suspension. And just in relation to an immediate suspension, that still requires fair procedures to take their course and for natural justice to take its course. So again, you would have a right to know about the incident. You would have a right to know what investigations the school is doing or intends to do. But I would recommend that if you look at the current guidelines now, they are being reviewed and so on. It highlights the areas that should be considered in advance of a student being suspended. And I've made a reference there on page 72 of the current guidelines, but that comes with the caveat that those guidelines are currently being reviewed by TESS at the moment. So one area that I wanted to look at to kind of maybe shine a light on the area of suspension and the codes of behavior is from a 2021 case, Board of Management of a special school, number 2021-91, which was a judicial review case. And this case in particular highlights what a school is expected to do in relation to the issues of suspension and expulsion. And just for some context, this was a case involving a special school and the suspension and expulsion of a student. In relation to this particular case, following the suspension of this student, which surpassed 20 days, the parents applied for a Section 29 under the Education Act. When the Section 29 committee is constituted, this is just an important point to note. It deals with a case in the legal terms de novo, but basically which means afresh. So the appeals committee are looking at the case from a blank kind of canvas, but they step into the shoes of the Board of Management, and they listen to the evidence of both parties, and on the back of that information they make a decision and they make a finding as such. With this particular case, the Section 29 committee held that the school did not exhaust all the local avenues or all of the avenues of support that could be available to this particular student, and kind of went ahead of themselves and suspended and subsequently expelled the student. So that was the findings of the Section 29 committee. The school then, as was its right to and entitlement to, then appealed that decision by the Section 29 committee on the basis that they noted that it erred in its decision, and that the decision that it made was effectively irrational. Justice Barr, who was overseeing the judicial review proceedings of that case, highlighted that in answering whether the Section 29 committee erred in its decision or acted what you might call ultra vires, which is going beyond the scope of the Section 29. He looked at three particular questions, and those questions are on your screen. Was the appeals committee entitled to inquire whether the school's authorities had made all necessary inquiries of other state agencies to support this student? B, if the appeal committee was entitled to undertake such inquiry, did it take into account irrelevant matters when reaching its conclusion? And C, was the decision reached by the appeal committee irrational, having regard to the totality of the evidence? And subsequently, the Justice Barr, in his decision, effectively quashed the decision of the Section 29 committee. He effectively said that the committee did have jurisdiction to make a finding as to whether the school did exhaust all of the avenues that were open to it, because that was identified in the school's code of behavior. But what he did say is that and I have a quote up here, is that the school, in his interpretation on the basis of the evidence, did exhaust all of the avenues in relation to the actions that the principal took to seek support via various external agencies, whether that be NEPs, or some home support that this particular child was in receipt of during this time. And just as at paragraph 120 of the judgment states, having regard to the very large number of interventions that had been trialled by the school, which were set out in extenso in reports prepared by principal, and which number 35 in total, it's hard to see that other interventions could be tried, and there was no evidence of any such specific intervention before the appeals committee. So basically, Justice Barr quashed the decision of the Section 29 committee on the basis that, in his opinion, and in his judgment, the school did exhaust all avenues that were possible, and that no further evidence was submitted that would show that there was an alternative provisions or avenues of support that the family could avail of. And ultimately, then the decision was quashed, and then it was remitted back to the Department of Education for the Department of Education to effectively establish a new Section 29 committee, and kind of starting the process all over again. Subsequently, that new Section 29 committee found in favour of the school, and as a result, then the individual was expelled from the school. But then the state also had that obligation under Article 42 of the Constitution to provide a primary education for this individual, and was subsequently sourced with a new school. So it just gives an example. But within that case, what happens? What if you read the judgment in of itself, you will see specific references to the codes of behaviour referenced throughout, and linking the nature of the incidents that arose, and then linking to the procedures or the processes that the school carried out in line with the codes of behaviour. Now, separate to this, you can read the judgment, then you could say, well, in my opinion, the judge was wrong, or the judge was correct. But I'll leave that to yourselves to decide in your reading. And there's good references to other judgments within that judgment that speaks about the test that the courts would look at when it comes to a student or young person being suspended or expelled. Justice Charlton, in a previous case, which escapes me at this moment in time, I think it's VC versus Waterford, goes in to establish what that test would look like. So I suppose just I'm conscious of time as such, and again, as Gareth said, it's hard to squeeze everything in such a short period of time. But if people do have particular queries that are related to a very bespoke nature, you can contact AsIAm, and we can obviously engage with your query. But just in sum, to kind of sum up the areas of that I looked at with regards to reduced timetables, they only should be used as a last resort, never used due to a school not having appropriate resources. A plan should be put in place whilst the child or young person is on a reduced timetable. Consent can be withdrawn at any time, or indeed not given, if the school is suggesting and indeed subsequently put the child on a reduced timetable. If the reduced timetable lasts for more than 20 days without consent, then the recourse then is through the school's internal suspension policies. And again, I said they should be made available to parents or guardians. And then just in relation to expulsions and suspensions, schools are required by law to set out their procedures on suspensions and expulsions. The right to be heard is a fundamental, and indeed right to impartiality is a fundamental aspect of natural justice in vindicating the rights of a young person if indeed their school place is in jeopardy. And it's important for parents and guardians to know what to expect of their school if their child is being threatened with suspension, or is on a suspension, or indeed is going through the potential probability of them on being expelled. The Board of Management, or if delegated to the principal, has the authority to suspend the student. And then finally, students' suspensions and expulsions must be in line with the school's code of behaviour as identified in the previous case. I would encourage people to read over the research that we produced there back in October of last year. It's included in the link below, and that just gives an insight into members of our community's experience of their school's code of behaviour, and how in many of these cases the student voice is not directly heard. And I will say that with the new review of the codes of behaviour framework, TES have been engaging with students, with family members, with advocacy organisations, and indeed, I suppose this is very welcome. So I'm going to stop sharing the screen now, and I'm going to stop recording, and we're going to open up the Q&A box, and stop recording. Yes.